afternoon, everyone. So we will be discussing today the questions and answers to the mock bar exam that you just took, okay? All right. So before we start, I want to remind you that when answering essay questions first, okay, there is a tendency that when you read the topic, you think that you know the answer because it may be related to something that you previously read. But sometimes it just makes you recall something you read, but it might not be exactly applicable. And the tendency is that you might force fit what you know to the question when that is not what is being asked, okay? So for you to avoid this from happening, I really recommend that you read the question at least twice, diba? Sometimes kasi if it only mentions the word privilege, you automatically assume the privilege communication rule applies, and then you will learn based on the question, ibang topic pala yung tinatanong, okay? So usually what you can do is you read the last part, what is being asked in the problem, so that when you go back to the top, you read the facts in light of what is being asked in the question, so that you will only take note of the relevant facts. And then after you read it, you go back to the start, read it again in its entirety, okay? Para you end up answering the question. And it goes without saying, yung tanong sagutin natin, diba? Is he liable? Yes, he is liable. No, he is not liable. Unahin nyo muna yung sagot sa tanong. Then, in one sentence, dapat ma-explain nyo na kung ano yung sagot nyo. Yes, he is liable because all the elements of the crime are present, period, diba? Then you can give maximum 3 of sentences to explain, and that's it, okay? You can give your jurisprudence. Usually, when you don't know the answer, okay, the advice is that you test it against what you know is the definition or the requisites. Always ganun lang yan, either kompleto requisites or kulang. So that should guide you. Do not leave blanks, sayang. Pero, wag naman panay hula per number. Kasi kahit kung may partial points ka, kung 20 numbers yan, o edi 20 over 100, bagsak pa rin. So dapat, alam mo pa rin talaga yung sagot, diba? Okay? So, anong gamot dyan? Okay? Kahit na magandang writing style mo, hindi ka naman nag-aral, walang magagawa. So, you really have to study very well, okay? So, know everything. Make use of simple sentences lang. Wag po tayong mga pa-essay writing contest na highfalutin, ha? Go and stick to simple sentences. Wag na yung compound. Pag di alam yung spelling, Diyos ko, wag nyo nang ipilit. Mahirap marong spelling. Dati, nung handwritten yung exam, madali lang yan. Guguluhin mo lang ng konti handwriting mo. Eh ngayon, nakatype na. O makita, di mo alam yung spelling. Kakahiya naman, diba? So make sure that when you're answering, you proofread your answers. Sabihin nila, ano ba naman to? Di marunong mag-spelling. Di dapat maging abogado. So, double check din po tayo ng pagsagot natin. Your answers should be straight to the point, concise. Okay? Hindi to pahabaan ng sagot. But it shouldn't be so short na walang laman. Yes, he is liable, period. Walang legal basis. You need to give your legal basis. Okay? Alright. So let's start with the questions. Okay. In the first problem, there is a Filipino, okay, and married to another Filipino in the Philippines, okay? 2 years later, the wife went to Japan to work as an OFW, where she met another man and fell in love, okay? So, the wife applied for and was granted Japanese citizenship. She then blatantly posted her photos with her paramour, publicly displaying affection on social media. So the husband, upon learning this, was heartbroken. So he applied for a divorce decree in Japan against his wife to dissolve his marriage against his wife. Okay, pwede ba yan? Yes, you can have that pursuant to the case of Republic versus Manalo. Diba? The Supreme Court finally allowed, if it is a mixed marriage, even the Filipino can be the one to obtain the divorce decree. Why? Because if the Filipino is not allowed to obtain that divorce decree, if the Filipino obtains it and it is invalid, it still leads to an absurd situation where the foreigner, insofar as he is concerned, the marriage is dissolved. He can still remarry. Pero yung Pinoy cannot remarry kasi invalid. So, inallow, even if it is the Filipino is the one who institutes the divorce decree in accordance with the law of the foreign country. Okay? But is obtaining the divorce decree enough? No. So, what happened was the husband, after obtaining the divorce decree in Japan, filed for a petition for recognition of foreign divorce decree in the regional trial court of his residence. Okay? Now, he applied for leave of court for issuance of summons by publication, and with the court granted leave, the summons was issued by publication. Subsequently, there was trial. The Japanese law was presented and proven as a fact, and the divorce was also proven as a fact, and there was no objection from the adverse party and the state. However, the court itself dismissed the petition. Why did the court dismiss the petitions? Hindi yata aware yung court in this case of the Republic versus Manalo ruling. Kasi sabi ng court dito, unfair naman yan na yung Pinoy kumuha ng divorce. It is like circumventing the law of nullity of marriage, diba? Tapos, it should not be allowed daw kasi contrary to the Constitution on preserving the sanctity of marriage if the Filipino obtains the divorce abroad, okay? So the husband moved for reconsideration of the dismissal and saying that dismissal with grave abuse of discretion. The MR is denied, okay? Those are our facts. We will have 2 questions here. So the first one is, was there proper service of summons, although no writ of attachment was previously obtained by the husband? Remember, the case is against a wife. The wife is a Japanese now who is residing in Japan and is no longer found in the Philippines. So it is a case against a defendant who is not found and is not residing in the Philippines. And under Section 17 of Rule 14 of the Rules of Court, you can have extraterritorial service of summons with leave of court, among others, where the case affects the status of the plaintiff. Definitely, this case affects the status of the plaintiff, right? And so, if it falls under that instance, you can apply for D for extraterritorial service of summons. The reason why you would ask for attachment first before applying for extraterritorial service of summons is because it does not fall under the list under Section 17, Rule 14. Ano ba yung list na nasa Section 17, Rule 14? For you to be able to avail of extraterritorial service of summons when the defendant is a non-resident or not found in the Philippines, the action should either affect the personal status of the plaintiff or it relates to the subject of which is property within the Philippines, where the defendant has or claims an interest, whether it is actual or contingent, or it pertains to the relief demanded consisting in whole or in part in excluding the defendant from any interest in that property, or the property of the defendant has been attached within the Philippines. So, if the action, for instance, is one for sum of money against a defendant who is a non-resident and is not found in the Philippines, you cannot immediately ask for extraterritorial service of summons. Why? Because that case, sum of money, does not fall under this list. It is not, sum of money is not about the status of plaintiff, neither does it relate to the subject of which the property is within the Philippines over which the defendant claims an interest. It is an action in personam for sum of money. So, what do you do so that you can avail of extraterritorial service? That in personam action, you must convert it to one falling under Rule 14, Section 17. And to convert it, what do? You attach, you apply for a writ of attachment so that it falls under the list. Ayan, it has been attached within the Philippines. But that conversion is only required, as I mentioned, if it does not fall under the list. If it falls under the list, such as pertaining to the personal status, then no need for you to convert it kasi pasok na siya sa listahan. You can just go straight and ask for leave of court for extraterritorial service of summons. So here, there was proper extraterritorial service of summons because leave of court was granted by the court involving a case who is a defendant that is a non-resident and not found in the Philippines, and the action affects the personal status of the plaintiff. Period. If you can see in one sentence, nasagot ko na yung tanong, applying the facts and the applicable rule. There is no need to attach the property before there may be application for extraterritorial service of summons. Diba? Alright? Okay. So, there's no need to obtain a writ of attachment to convert because the status of plaintiff pertaining to the case falls under Section 17 of Rule 14. Diba? Okay. Alright, what are the different modes of service by extraterritorial service? Okay, under Section 17, Rule 40, it can be by personal service under Section 6, or as may be provided by international conventions to which the Philippines is a party to that treaty or international convention, or by publication in a newspaper of general circulation. Saan? In such place and in such time as the court may order. But under this third kind, the publication must be coupled with service of summons also set by registered mail to the last known address of the defendant. And last is in any other manner the court may deem sufficient. In this case, there was publication, but the publication, unlike the requirement under the third instance, is not coupled with mailing in the last known address by registered mail. Is that valid? According to the Supreme Court, yes, because there are 4 modes. The last one is in any manner that the court may deem sufficient. So if the court orders that it is only by publication without being needed, without being coupled with mail by registered mail in the last known address, that is valid, it is sufficient, it falls in any other manner, the court may deem sufficient. Like in this case, alam naman natin that the Japanese is not in the Philippines, she is abroad. Okay, that's where she's residing. So, there's no point naman na daw sending it in the last address sa Pilipinas na wala namang tao. Yan, okay? Now, remember what is the reason of the court for dismissing the case? Contrary daw sa Constitution, yung pag-allow na yung Pinoy yung kumuha ng divorce, diba? Okay? So, saan na yung judgment natin? Okay, ayan. So, here, he timely moved for reconsideration, which is denied. What is the better remedy? Here, the only issue is whether tama. So, ang issue is yung dismissal. Is it contrary to the Constitution? Okay? Is it contrary to the Constitution for the Filipino to obtain the divorce decree abroad? This is a pure question of law. And so, the issue of whether you circumvent the rule on nullity of marriage and it is contrary to Constitution is a pure question of law. If it is a pure question of law, the remedy is by Rule 45 to the Supreme Court. How come it is not by notice of appeal to the Court of Appeals? If you go to Rule 50, Section 2, the rules mention that if you take an appeal by Rule 41, meaning that is the judgment of the RTC in its original jurisdiction, and you appeal it for the first time to the CA by Rule 41, If the issue there is a pure question of law, the CA shall dismiss it. So the CA under Rule 41 on an appeal of a judgment of the RTC rendered in its original jurisdiction cannot entertain pure questions of law. It is not reviewable by the CA. Remedy is to go by Rule 45 to the Supreme Court. Why? Rule 45, Section 1 says, a party deciding to appeal by certiorari from the judgment of the RTC, pwede yan, basta pure question of law. But if the judgment came from the MTC you appealed to the RTC. RTC affirmed the ruling. This time you want to appeal the ruling of the RTC in its appellate jurisdiction. So you go up to the CA, but rather than Rule 41, it is Rule 42. What if you want to appeal the RTC decision rendered in its appellate jurisdiction, meaning galing na yan sa MTC, and you only want to raise up your question of law? Should you go by Rule 45 to the Supreme Court? Answer, no. You should go by Rule 42 to the Court of Appeals on a petition for review. Why? Because Rule 42, Section 2C says that the Court of Appeals, in reviewing the decision of the RTC under Rule 42, where the decision of the RTC is rendered in its appellate jurisdiction, can entertain questions of fact or law or both. By that wording, it means that the CA can entertain a pure question of law coming from the CA under Rule 42, coming from the RTC rather. The CA can entertain questions from the RTC under Rule 42 involving pure question of law, meaning it is the decision of the RTC rendered in its appellate jurisdiction. Okay? But if it's the decision of the RTC rendered in its original jurisdiction, where do we go? Supreme Court by Rule 45, if pure question of law. Okay? All right. The debtor obtains a loan against the creditor and the loan is secured by chattel mortgage. Natawa ba kayo sa mga names na nilagay ko sa MacBar? At least habang nahirapan kayo, tumawa kayo. O, di ba? Tagal kong inisip yan, yung mga pangalan na yan. O, di ba? Okay. But do not feel frustrated if you didn't get the correct answers. Ang point, malaman nyo yung answer ngayon rather than after the bar, di ba? O, mahirap na buhay, huwag nyo nang pahirapan pa sarili nyo, di ba? Di nyo alam dati, at least ngayon alam nyo na. Alright, so the loan is secured with a chattel mortgage over a car of the debtor. When the loan fell due, the creditor made a demand for the debtor to pay. Despite demand, the debtor did not pay. Now, the creditor, for him to be able to foreclose the chattel mortgage, he needs the car, but he cannot find it despite demand for the debtor to surrender it. So the creditor learns that the debtor is purposely concealing the car to prevent the creditor from foreclosing the mortgage. What is the remedy of the creditor? Take note that the issue here is that the creditor wants to be able to foreclose the mortgage. To foreclose the mortgage, he needs the car over which the chattel mortgage is constituted. Since there is a withholding of movable property, which is a car, and the creditor, being the mortgagee, has the right to possess it pursuant to the chattel mortgage for him to foreclose the same, the remedy is replevin, to recover possession of the car and to proceed with the foreclosure of mortgage. Remember, replevin can be either a main action, it can also be a provisional remedy, and it is a remedy praying for recovery of possession of personal property. You don't have to be the owner to be entitled to a writ of replevin. All that is required is either you are an owner or you have the right to possess. Okay, so you have to be entitled to possession. Okay, all right. The husband and the wife are both Filipinos, and they were married. Okay, and after 2 years of married life, the wife files a petition to declare the marriage with the husband void on the ground of psychological incapacity. The wife presented an expert witness, a psychologist, to establish that her husband was psychologically incapacitated. All right? Okay. Now, the family court denied the wife's petition for nullity of marriage because although the psychiatrist did not prove the psychological incapacity, only that he has a narcissistic antisocial personality disorder. But according to the court, the petition should be dismissed kasi it's not enough for you to prove that you have a psychological disorder. You need to establish the link between that and the inability to comply with the marital obligations, the gravity, incurability, and juridical antecedents of the psychological incapacity that show the failure to understand and comply with the essential marital obligations. After the decision dismissing the nullity of marriage became final, the wife files a second time a petition for nullity of marriage, this time absence of marriage license a formal requisite. The husband moves to dismiss the petition for nullity of marriage on the ground of res judicata. All right? The court grants the dismissal. Okay? After 2 months after the finality of the decision, the wife's counsel informs her of the decision. The counsel explains he was not able to see the decision on time because he was out of the country and his staff did not timely inform him. So the period to appeal has already lapsed. So the counsel recommends to the wife that they file either a petition for relief for judgment, and then if that is denied, file a petition for annulment. Okay. The first question is, was the dismissal of the second action for nullity of marriage on the ground of lack of marriage license proper on the ground of res judicata? Okay. Yes. Why? there are two actions here, but they arise from the same cause of action. It is nullity of marriage. They are just based on different grounds, but there is a single cause of action which pertains to the validity of marriage between the same parties. So it is already, the dismissal in the first case bars the second case, there is already res judicata, okay? Although there are different grounds for nullity, they are the same cause of action. So the rule is that you should already raise all the grounds for nullity of marriage in the first action, okay? All right, what do you mean by res judicata? It is when a thing is judicially acted upon or decided on. It is a thing or matter settled by judgment. So this refers to the rule that final judgment on the merits by a court of competent jurisdiction is already conclusive of the rights of the parties or their privies in all later suits on points and matters determined in the former suit. You can find res judicata under Section 47, Rule 39, specifically under paragraph B as in boy and C as in che. All right, under Rule 39, Section 47, it states that the effect of judgment or final order rendered by a court of the Philippines that has jurisdiction to pronounce judgment or final order may be as follows, okay? Letter B pertains to bar by prior judgment or estoppel by verdict, okay? So here, the judgment bars the prosecution of a second action upon the same claim, demand, or cause of action. Paragraph C pertains to conclusiveness of judgment or author action pendant. This is where the issues are actually and directly resolved in a former suit cannot be again raised in any future case between the same parties, although it may involve different causes of action, okay? Now, what are the requisites for there to be barred by prior judgment? Number one, the former judgment is final. It is rendered by a court having jurisdiction over the subject matter and the parties, and it is a judgment or order on the merits. And as between the first and second actions, there is identity of parties, subject matter, and causes of action. So here, res judicata is clearly present because all of the elements are present. The petitioner, the wife, was only invoking different grounds, but they arose from the same cause of action, which is the nullity of marriage. So by invoking the different grounds in different cases, the wife was splitting the aspects of the issue, okay? Barred by res judicata, all right? Okay. A man and a woman were engaged to marry in 3 months. A day before the wedding, the man posts publicly on social media saying that he needs to be true to himself and he will not anymore marry the woman, mentioning her name, because ang baho ng anghit niya. She smells bad. She has body odor. And gumuguhit daw hanggang kaluluwa niya. Oh my gosh. Hindi daw niya matiis. There will be no wedding tomorrow. So the woman was truly humiliated and hurt by what the man did. So the woman files a complaint against the man for moral damages in the amount of 5 million. Exemplary damages in the amount of 2 million. And according to the woman, she suffered sleepless nights, hurt feelings, anxiety. Why? Because those public statements humiliated her. Diba? And he broke off the wedding in bad faith. So she said that the exemplary damages should be imposed on him as an example. In his answer, the man said, the truth will set him free. And it should set her free din daw, o, diba? Okay. And then he attached affidavits of his friends that support his allegation that indeed the woman had body odor, which smelled bad. So after that answer, the woman claims that the man did not really specifically deny that he acted in bad faith and that she suffered sleepless nights. And so she moved for judgment on the pleadings. And the court granted it and rendered already a decision that granted the amount of exactly what was prayed for. 5 million exemplary damages, 5 million moral damages and 2 million exemplary damages. Okay. The man moved for reconsideration against the decision on the ground that it was premature for the court to make such ruling already. Rule on the motion for reconsideration. It should be granted. Why? Although the man did not specifically deny that he acted in bad faith or that he hurt her feelings, the rule is that the failure to specifically deny the material allegations, okay, will constitute as an admission of the material allegations in the complaint, except for the amount of liquidated damages. So it's correct, he admits that he will be liable, that he acted in bad faith, that she got hurt. But he does not admit the amount of unliquidated damages of the 5 million, 2 million. The moral damages and exemplary damages, although that's what she's asking for, these are in the nature of unliquidated damages. Even if not specifically denied, they are not deemed admitted. It needs to be proven, okay? So the court cannot just give an amount without proof. So there needs to be trial as to the amount of such damages, okay? So that is not part of those deemed admitted, okay? All right. A man and a woman applied with the local civil registrar for a marriage license. After they submitted all of the requirements and complied with all required by law, they were refused release of the marriage license. Okay, as it turns out, okay, the man was the local civil registrar's former boyfriend, and the local civil registrar could not accept that her former boyfriend was getting married to another. So both the man and the woman applied in court for a petition for mandamus against the local civil registrar to direct her to issue the marriage license, which was granted. Okay. Now, despite the order of the court, she does not comply with the order to issue the marriage license. Okay, what are your, first, if you are the LCR or the local civil registrar, what would be your remedy against that ruling? So if you're the adverse party, you can either file a motion for reconsideration within 15 days from notice of judgment, or you file an appeal by ordinary appeal, whether directly from notice of judgment or from notice of the order denying the motion for reconsideration, subject to the fresh period rule, where you have a fresh period of 15 days from notice of denial of the order denying the motion for reconsideration. The appeal here, where the judgment is from the RTC, is by ordinary appeal only, Rule 41 to the CA. Why? Because a petition for mandamus is an original action. You file it, in this case, filed with RTC, so it was filed in original jurisdiction. Okay? Now, what is the remedy? Assuming the writ of execution is issued, but the local civil registrar refuses to comply. Okay? Rule 39, Section 11 talks about special judgments. These are the judgments that do not fall under Section 9, Rule 39, and Section 10, Rule 39. If you go look at your codal, you will see that Section 9, Rule 39 talks about judgments for sum of money. Remember, if it's for sum of money, how do you execute it? The sheriff first makes a demand for you to pay. If you cannot pay in money or other manner that is acceptable to the judgment creditor, then they will levy, attach, garnish. It will be sold at an auction, the proceeds to pay the debt or the judgment. Section 10, yan yung mga specific acts to vacate property, return possession, convey title. Okay? Then, Section 11, these are those that you can also have someone else done at the expense of the debtor or defendant or the losing party. But Section 11, you cannot have someone do it for you. Okay? What is specifically required to do it? So here, only the local civil registrar can issue that marriage license. So how do you execute that ruling? The ruling is executed by serving a certified copy of the judgment together with the writ of execution on the party against whom the same is rendered. In this case, the local civil registrar. And like in this case, the local civil registrar refuses to comply, then that person will be punished for contempt. O, diba? Ikulong nyo siya hanggang sumunod siya. Okay? Alright. Will the filing of an action for injunction with the Court of Appeals to restrain the ruling of the RTC Manila prosper for the LCR? Note that the question here is an action for injunction. So it's not a provisional remedy, but an original action. Remember, injunction can be a provisional remedy. It can also be a main action. As a main action, does the CA have jurisdiction? No. It is not among the list of cases under the original jurisdiction of the CA under BP 129 as amended. The court that has exclusive original jurisdiction over injunction cases is the regional trial court. Why? Because it is incapable of pecuniary estimation, and also because it does not fall under the jurisdiction of other courts. So if you file an original action with the CA for injunction, that will be dismissed because the CA does not have jurisdiction. The jurisdiction of the CA for injunction is only as an ancillary remedy if it is filed as a provisional remedy together with another main action pending in the CA. All right. Okay, let's move on to number 6. All right, there is now a contract to sell. Okay, so there is a contract. Note that it is not a contract of sale, but a contract to sell. Remember, in contract to sell, the prospective seller reserves the title and ownership in his name until there is a full payment of the purchase price. So here, there is a contract to sell, and it involves a land with an assessed value of 300,000 and a purchase price of 5 million payable in 12 equal monthly installments. Okay, now, because of the failure of the potential buyer to pay the last installments or the 3rd to 5th installments despite demand, the potential seller now files a complaint in the regional trial court for rescission of the contract to sell due to the material breach. Okay, the defendant moves to dismiss the complaint on the ground of lack of jurisdiction over the subject matter because they are claiming that it involves title to possession over real property, and therefore, since the assessed value is 300,000, it should be in the MTC, okay, that has jurisdiction over the same. The regional trial court denied the motion to dismiss for being a prohibited motion. Okay, the case proceeded to trial, and after trial on the merits, the regional trial court dismissed the complaint for lack of jurisdiction over the subject matter, ruling that it is a real action and MTC has jurisdiction. The plaintiff moves for reconsideration, which was denied. Okay, first ground. The first motion to dismiss was on the ground of lack of jurisdiction. Is it correct that it is a prohibited motion? No, it is not a prohibited motion, okay? Because a motion to dismiss as a rule is prohibited, but it is subject to exceptions. What are the exceptions? Lack of jurisdiction over the subject matter, res judicata, litis pendentia, and prescription. So it was incorrect for the trial court to say that a motion to dismiss for lack of jurisdiction over the subject matter is a prohibited motion. It is an allowable motion to dismiss. If you look at Rule 15, Section 5.8, under the list of litigious motions, it includes a motion to dismiss. So not all motions to dismiss are not allowed. There are litigious motions, such as a motion to dismiss, that are allowed. And specifically, under Rule 15, Section 12A, under the list of prohibited motions, it includes motion to dismiss as a prohibited motion, but it mentions, excuse me, it mentions exception. What are the exceptions? These are the 4 non-waivable grounds provided under Rule 9, Section 1, lack of jurisdiction over the subject matter, res judicata, litis pendentia, and statute of limitations. Ayan, okay? Now, did the regional trial court have jurisdiction over the complaint? Because the ruling of the court is that it is the MTC. Why? Kasi daw its assessed value is 300,000. It is a real action. It should be the first level court. Is that correct? Mali. Why? This action does not involve title to possession or interest over real property. Remember, if the issue pertains to title to possession or interest over real property, the basis of jurisdiction is the value of the assessed value of the real property. But here, it is not a contract of sale where there is transfer of ownership of land and you want to recover back the land. No, this is a rescission of a contract to sell. There was no transfer of ownership of the land. So you're not asking to recover land. You just want to rescind the contract. And that agreement is incapable of pecuniary estimation. When is it capable of pecuniary estimation? It's capable of pecuniary estimation if it involves recovery of money. But here, you're not recovering money. You're just canceling, rescinding the contract, okay, for the parties to be back in their situation prior to entering the contract. So this is an action that is incapable of pecuniary estimation that falls under the jurisdiction of the regional trial court, exclusive original jurisdiction. Okay? All right. Now, the accused is charged with murder. Alleged in the information are the correct allegations for the crime of killing with an aggravating qualifying circumstance to make it murder. All right? So what is the penalty for murder? That is reclusion perpetua. Okay? It is not automatically bailable. Okay? Now, during the trial, okay, the prosecution presented evidence. However, all that the prosecution could prove was the fact that the accused killed the victim, but they could not prove the alleged aggravating qualifying circumstance. Okay? What was only proven was that the victim died in a heated argument instantly. Okay? All right. Now, after the prosecution rested its case, this time, the accused files a petition for bail. And now there is a hearing to determine whether the evidence of guilt is strong. And after that, it is argued by the accused that the evidence of guilt is not strong for murder and he should be allowed bail. But the court denied it. Why? Because according to the court, there is evidence of the killing. And it's strong dahil patay na po ang biktima. Alright? So, the bail was allowed. So, the accused moves for reconsideration because according to him, the aggravating qualifying circumstance of treachery alleged in the information is not present if there is a heated argument. That is the doctrine, okay? Cannot be treacherous if the death is arising from a heated argument, okay? All right. Was it correct for the court to deny bail? Okay. Here, the basis of the grant or denial of bail, if the penalty is punishable, is prescribed is reclusion perpetua, is whether the evidence of guilt is strong or not for the crime charged. What is the crime charged here? Murder. And prosecution was able to present evidence only of the killing, but the treachery was not established. In fact, jurisprudence says that if there is death through a heated argument, treachery is not present. So, the court denied bail because there is evidence of killing, but that is not the threshold requirement to determine whether bail should be allowed. It is evidence of guilt of the crime charged. Proof of killing is just homicide, okay? But for you to be able to deny the bail, dapat evidence of murder is strong. Here, the evidence for murder is not strong because the only evidence is for homicide. And therefore, the evidence of guilt for murder is not strong. Bail should be allowed. Ayan. All right? Okay. Let's move on to the next number. The mayor, while interviewing an applicant for the position of a secretary, all of a sudden stood up and pinned that applicant to the table, and he forced himself on her and raped her. Okay? The secretary screamed for help, but when help arrived, the deed was done. The mayor was charged in the information as follows. Okay, that Mr. Maniac, then mayor of Pangasinan, while in his office and while performing his duties of mayor in interviewing the victim, an applicant for the position of the mayor's secretary, suddenly stopped the interview, stood up, and pinned the victim to the table, putting his full weight on her and addressed her forcefully against her will and her protestations, ripping off her clothes, inserting his male genitals into her vagina as she continued to scream for help and push against him. The treasurer of Pangasinan arrived after breaking the door open and found the mayor on top of the victim with his male organ inside her vagina, contrary to law. All right, based on the allegations in the information, which court has jurisdiction? Okay, who committed the crime? Mayor. Okay, this is the Sandigan Bayan jurisdiction. Although it is not 3019 forfeiture of ill-gotten wealth or bribery, direct, indirect, qualified, or corruption of public officials, still, the crime committed was intimately connected with the performance of duties done while in the performance of duties, although improper or irregular. It is not the duty of the mayor to rape, but he had access to the victim because he was in the performance of duties of interviewing her. So although improper or irregular yung paggawa niya ng crime, he was able to do it because it is intimately connected with the performance of his duties. Therefore, it is the Sandigan Bayan that has original jurisdiction. So once the Sandigan Bayan makes a ruling, what is your mode of appeal? You are assailing here the judgment of the Sandigan Bayan rendered in its original jurisdiction, right? So if it is the judgment of the Sandigan Bayan rendered in its original jurisdiction, the mode of appeal is the appeal for the first time. It is notice of appeal to the Supreme Court, okay? You file the notice of appeal with the Sandigan Bayan, and thereafter the records will be forwarded to the Supreme Court. So it is by notice of appeal if you are appealing the decision of the Sandigan Bayan in its original jurisdiction. But if the decision came from the RTC involving public officers, you appeal to the Sandigan Bayan by Rule 41. Then from the Sandigan Bayan, you go up to the Supreme Court, this time Rule 45, if you are appealing the decision of the Sandigan Bayan in its appellate jurisdiction. Ayan, okay? All right. A school's portal was hacked by an unknown hacker and sensitive personal data of students and faculty were leaked online. There is an informant that informed the NBI that the suspect is Mr. X. Okay? According to the informant, he saw the computer of Mr. X that contained the images and codes that proved the hacking. Okay? So, the NBI conducted surveillance and investigation, and they gathered probable cause that Mr. X was indeed behind the cybercrime. So, the NBI was confident once they are able to get the computer system and analyze its contents, they can prove beyond reasonable doubt that Mr. X is the perpetrator. Okay? Now, let's assume that they applied for a cyber warrant and they were granted a cyber warrant. Okay? They go now to the residence of Mr. X to serve the same. Upon service, they were allowed entry kasi nga may search warrant sila. And pagpasok, in plain view, they could see the computer system turned on and it shows the hacking, okay, of the school portal. Okay, without a warrant. Okay, rule on the validity of arrest. Is that a valid warrantless arrest? Answer is yes, okay? Although they were trying to effect a search warrant, they saw in front of them a crime was being committed or is actually being committed in flagrante delicto, which is the hacking of a school portal. So with that, it is falling under one of the valid warrantless arrests, which is an in flagrante delicto warrantless arrest. Okay, so it is an arrest without a warrant that is valid. Okay, all right. O, dali lang, diba? All right. An accused was charged with qualified rape. Okay, the information alleges that the accused had carnal knowledge by means of force, intimidation, and threat against a minor by taking advantage of his moral ascendancy. What is the source of the moral ascendancy? That the perpetrator is the step-parent. Ibig sabihin, the perpetrator married the mother of the victim. Ayan, okay? Now, based on evidence presented, the fact of rape or the act of sexual congress with the victim was established. However, the relationship of step-parent and stepchild was not established. Why? Because instead, what was proven is that the perpetrator is not the step-parent. Actually, he never married the mother of the victim. They are actually just common law spouses and they are not legally married. Okay? So, after the prosecution rested its case, the accused moves for leave of court to file demurrer to evidence. Leave of court was granted and demurrer to evidence was filed. According to the accused, there is failure to establish his guilt beyond reasonable doubt. He must be acquitted. Should the demurrer to evidence be granted? No. Why? Here, what was proven was clearly the act of sexual congress, the act of raping the minor. What was only not proving is the qualifying aggravating circumstance of the relationship or the relationship between step-parent and step-daughter. Okay? But the elements of the crime of rape were proven beyond reasonable doubt. Demurrer will only be granted if you're not able to prove the crime. Here, we were able to prove the crime of rape, just that it is not qualified. Okay? So, just because what was established is only common law relationship between the parents, but that relationship does not mean no crime was happened because the crime of rape actually happened. So what will happen here is that although he cannot be convicted with qualified rape, he can still be convicted of simple rape. Ayan, okay? So if the demurrer to evidence is denied, okay, what is the remedy of the accused? Since it is a demurrer to evidence with leave of court, he can still proceed to trial and present evidence in his own defense. The burden of evidence shifts to the accused to controvert the prima facie case against him. Ayan, okay? And once there is judgment rendered, if he is convicted after trial, then he can appeal. Ayan po, okay? All right. Now, there is a child of spouses and the husband sues the wife for adultery. In the trial, the child will testify for the husband against the wife. But the wife objects that she cannot testify because of the parental filial privilege rule. Okay, is this correct? If you look at Rule 130, Section 25, the prohibition is not about testifying. the prohibition is about being compelled to testify. So in this case, there is no showing that the child is being compelled to testify. So if the child wants to testify, she can do so voluntarily. What is only prohibited is to be compelled to testify against your parent. But that rule is subject to the exception where the testimony is indispensable in a crime against that person or by one parent against the other. So the exception does not apply here because there is no compulsion here. The child is voluntarily testifying. And more importantly, it is not the wife or the parent who can invoke the disqualification under this rule, but it belongs to the child. Okay? All right. All right. The victim was stabbed twice. One is fatal. The first one was not fatal. The second one was fatal. So the victim was immediately brought to the hospital where he underwent surgery. Right after his surgery, he talked to the nurse and told the nurse the perpetrator of the crime. He identified the perpetrator, the one responsible, and subsequently he died from his injuries. So now, since the victim is dead, the nurse will testify in a criminal case against the perpetrator to identify the perpetrator as the one who killed the victim. Now, this is a testimony that is invoked under the exception of the hearsay rule, where it is admissible hearsay. It's hearsay as to the nurse because the nurse did not have personal knowledge of whether or not the perpetrator did it to the victim, but it falls under admissible because it is a dying declaration. Now, however, the accused argues it cannot fall under dying declaration because there is no consciousness of an impending death. Now, why? Because the victim mentioned this after surgery. Pag after surgery, hindi mo na daw iisipin mamamatay ka. Okay, is that correct? Alright, look at the question. Is the testimony admissible under dying declaration? So if you answered, it is admissible under res justae, hindi yan yung tanong. Okay? Yung tanong, is it admissible under dying declaration? Pag tinanong, is it admissible, pwede mo sabihin res justae, dying declaration, whatever. Pero kung limited lang yung tanong sa dying declaration, then you only test it against the requirements of dying declaration. And according to the Supreme Court, in this case, all of the elements of dying declaration are present. Okay? That it pertains to the cause surrounding the circumstances of his death. There is no showing he would have been incompetent to testify had he survived, and it is offered in a case against the accused where the subject inquiry involves the declarant's death. Now, according to the Supreme Court, the fact that the declaration was made after the victim underwent surgery operation does not necessarily mean he is out of danger. Diba? It does not mean that there is no more consciousness of an impending death. Diba nga pag may ooperahan, prayers please, ganyan. O kasi pag kahit operahan, pwedeng dun ka pa mamatay, diba? So walang certainty that if you're operated, you will not anymore, that you will survive or you will not die, okay? So walang ganon, sabi ng Supreme Court. Even, okay, even, and sabi ng Supreme Court, the fact that there is consciousness of impending death can be shown by the fatality of the injury and the fact that he immediately died thereafter. Ayan, okay? So, considering the seriousness of the stab wound inflicted and that he died shortly after despite undergoing operation, it can be concluded that he was aware of his impending death when he made a statement that it was the accused who stabbed him. Ayun, okay? Alright. Okay, so considering the seriousness of the stab wound inflicted and that he died shortly after despite undergoing operation, it can be concluded that he was aware of his impending death when he made a statement that it was the accused who stabbed him. Ayun, okay? Alright, there was a man roaming the streets of Manila. Now, the police immediately brought him to the police station by arresting him without a warrant and questioning him whether he used drugs. He was interrogated 10 hours non-stop until finally he admitted to using shabu and to selling shabu. He said, I'm a supplier. You can find the supply of shabu in my house. So the police asked him to bring them to his house, and he did so. And when they arrived there, they called for the mayor to witness the photographing and inventory of the shabu, but no marking was made. Okay? And according to them, they went to the house immediately to get the shabu because this happened at midnight, and the admission was made around midnight, and there were no representatives from the media and National Prosecutor Service, and they did this so that the accused would not tip anyone to throw the shabu away. Are the seized items admissible? No, they are not admissible. Why? They are the fruits of the poisonous tree. Why? There's no search warrant here, but a search warrant is not always required for us to have validly seized items. Okay? Pwede maging valid yan without a search warrant as long as it is not an unreasonable search and seizure. However, how were the police able to search for the items? Because of the admission or confession of the accused that he is a seller of drugs. But when did he confess to that? In a custodial investigation. And for an extrajudicial confession by the police, before the police in a custodial investigation to be valid, it must be in writing and done with the assistance of counsel. Here, he was not assisted by counsel, and it was not in writing, that extrajudicial confession is inadmissible. And the confession there pertaining to the shabu where it is located is a fruit of a poisonous tree. Additionally, it cannot fall under a search as an incident of an arrest. Why? Because the arrest was invalid. There was no reason to arrest him as he was only roaming the streets. That is not a crime, okay? It does not fall under warrantless arrest, okay? And also, it was not a search within the immediate control at the place of arrest. Pumunta pa sila sa bahay. So, it is inadmissible. All right, now, they called the mayor to witness it. There is no representative of the NPS and there is no representative from the media kasi 12 midnight na daw, nagmamadali sila. Is that justified compliance with the chain of custody? There was only inventory, photographing, no marking. According to the Supreme Court, no, that is not valid. Why? Number one, class, if you are going to make follow the chain of custody rule, although marking is not mentioned in the rule, the Supreme Court said marking is indispensable. There must be marking because that distinguishes the drugs seized from the other drugs in other cases. So you need to have marking. Second, they only alleged na walang available from media or national prosecutor surface. But according to jurisprudence, mere allegation of unavailability is not enough. They need to show us earnest efforts to comply with the rule. Wala naman. They need to acknowledge the breach, and the prosecution needs to be the one to go forward and explain the breach, why it is justifiable, and that they showed earnest efforts to comply. It was not complied with in this case. And what is the effect if there is a breach in chain of custody? It does not render the drugs inadmissible, ha? Yung inadmissibility, yun yung sa unreasonable search and seizure. Pero yung violation ng breach of ng chain of custody does not affect the admissibility, but it affects the credibility or probative value of the drugs. Since you breach the chain of custody and there is no justifiable reason, and you did not show that the integrity and identity of the drugs are preserved, there will be doubt as to the integrity of the drugs seized, doubt as to the identity of the drugs seized. If there is doubt, then you cannot establish the corpus delicti beyond reasonable doubt. And if you cannot do that, there cannot be moral certainty that the crime was committed. You cannot prove it beyond reasonable doubt. The effect, you will need to acquit the accused. Ayan po ang epekto ng lahat. Alright? Okay. The Commission on Audit, text number. The Commission on Audit, alright, made the COA rules provide that a majority vote of those who deliberated in the session is to arrive at a decision, okay? In their deliberations, 2 out of the 3 members voted to deny the disbursement. 1 voted to grant it, okay? But before that decision could be promulgated, the one who voted to grant it retired. Okay, now, the claimant files a petition for certiorari under Rule 65 within a period of 60 days from the notice of said decision since it was grave abuse of discretion for the COA to violate their own rules, okay? Is the claimant correct? No, okay? Because on the whether or not the disbursement of claim should be allowed, this is an exercise of the COA's adjudicatory functions. And therefore, it is not the 60-day period under Rule 65 that applies to review that adjudicatory function decision, but it is Rule 64, 30 days. But if instead, let's say it's the COMELEC that issues a resolution on the gun ban that is pursuant to its rulemaking power, not adjudicatory function, the period applicable for certiorari to assail it is Rule 65, 60 days. Okay, not Rule 64. Why? The 30-day period under Rule 64 is only applicable when you are assailing the ruling of the COMELEC or the COA that is rendered in the exercise of its adjudicatory functions. All right? Okay. All right. There is a pacto de retro sale where there is an agreement to sell a land for 1.5 million, okay, with the right to repurchase in 2 months. So it is a pacto de retro sale. When the 2-month period lapsed, okay, the buyer, a retro, allowed the seller, a retro, another extension. That period of extension lapsed and there was no repurchase. So the buyer a retro now goes to the registry of deeds to have the title transferred and registered in the name of the buyer a retro and canceled in the name of the seller a retro. Okay? All right. Now, the seller a retro says that he wants to file an action to nullify that sale because it's actually simulated. Okay? All right. All right. So sinasabi niya it is actually one for equitable mortgage. Ayun. So, let's say that an action for nullity of sale proceeded and the court found that yes, there is really no sale. It's really a loan with mortgage. If the court finds that the pacto de retro sale is really a loan with mortgage, what will be the remedy of the buyer a retro, which is actually a creditor? The creditor's remedy, if there is a finding that it is not a pacto de retro sale, but one for equitable mortgage, is to bring an action for sum of money to recover the loan or to foreclose the mortgage, whether judicially or extrajudicially. Ayan, okay? Alright? Okay. Okay. Remember, under Rule 63, under other similar remedies, that includes the instance of consolidation of ownership in a pacto de retro se, or conventional redemption. Once the period of redemption lapses there, you cannot just automatically transfer title in your name. You need to file a Rule 63 petition, okay? Because the rules and the law provides that you can only transfer title in the name of the buyer a retro after judicial ruling. All right, there are two persons claiming the right to collect rent against the lessee. Nag-aaway-away sila. Sabi ng lessee, ano ba naman? I'm torn between two demanders, feeling like a fool. And so, she files a complaint for interpleader against these two contending claimants. Okay? In the answer, defendant 1 prays for the issuance of preliminary attachment over the plaintiff's property. Why? He wants the property of the plaintiff attached in an amount equal to the value of the unpaid rent to secure the recovery of unpaid rent. The defendant, on his part, applies for issuance of TRO to restrain the plaintiff from spending the rent or turning it over to the other defendant during the pendency of the case. First question, will the writ of preliminary attachment prosper? Remember, the first defendant moves to attach the plaintiff's property in an amount equal to the unpaid rents, the subject matter of the case. Is that going to be granted? No. That's not one of the grounds for issuance of a writ of preliminary attachment. Remember, as we discussed before, the list of grounds for issuance of a writ of attachment under Section 1, Rule 57 is exclusive. Okay? What about the issuance of a TRO to restrain the plaintiff from giving the rent to the other defendant during the pendency of the case? Will it prosper? No, the requisites of TRO are not present. First, the second defendant has no clear legal right. The main purpose of the action is to determine who has a right to the rentals. That is exactly the subject of dispute. So TRO cannot issue. Also, there is no urgency shown or irreparable injury. And there is another plain, speedy, adequate remedy available. What is the more speedy, adequate remedy available? Just ask the court to issue the provisional remedy of a deposit order to have those unpaid rentals deposited in the court and place it in the court's custodial legis. Ayan. All right? Okay. Let's move on. All right? The husband and the wife were married in January 2, 2020. The spouses never had children, and their property regime is complete separation of property. Okay? After the marriage, the wife had extramarital sexual relations with another man. Upon discovering the affair, the husband files an action for legal separation against the wife. Okay? Now, during the pendency of the legal separation case, the wife now files an action for nullity of marriage against the husband on the ground of absence of marriage license. The wife knew about the pending legal separation case, but she never disclosed it in the certificate against forum shopping attached to her petition for nullity of marriage. So the husband says that the case should be summarily dismissed because of the failure of the wife to comply with the required allegation in a certificate against forum shopping without any justification, and for her to be cited in contempt of court. Is that correct? The failure to disclose the status of the legal separation case in the certificate against forum shopping is not a violation. Why? Although the legal separation and nullity of marriage cases involve the same parties, they do not involve the same cause of actions. They include totally different issues. In legal separation, the marriage tie is preserved. They remain married. There is only a separation of bed and board. In nullity of marriage, that is where there is the severance of the marriage tie. The marriage is nullified. Okay? So these are entirely different causes of action. And in the certification against forum shopping, the disclosure is required only for those with the same issues, identity of causes of action, and relief sought between the two cases, which is not present in this case. So that omission, okay, where of the legal separation case, okay, is where the legal separation, a judgment on it is not constituting res judicata or litis pendentia. So that omission in the certificate is not fatal. It is not contempt. All right? Okay. There is an expropriating authority that entered the land of the landowner without their knowledge, without their consent, and without instituting expropriation case. In 2010, in 1998, they entered it and started building transmission lines. Okay? Now, the question is, when is the reckoning point for the determination of just compensation? The rule is whether it is expropriation or inverse condemnation. The reckoning point is at the time of entry or at the time of the filing of the action, whichever is earlier. Here, based on the facts, no action was filed. So the reckoning point is from the time of entry when they started building the transmission lines in 1998. The ruling in heirs of Sangkal, where the court reckoned it not from the entry but from the time of filing, is the exception. Heirs of Sangkal is not the rule. The rule is either entry or filing, whichever is earlier. In the case of heirs of Sangkal, nauna yung entry before filing, but the court allowed it to be reckoned from the later date of filing because in this case, what was built on the landowner's land are underground tunnels. It was surreptitiously made. It was completed without the knowledge, consent of the landowner. Okay? So as a simple measure of justice, the court allowed it to be reckoned from the time of filing, which is later than the entry. Kasi hindi nila nalaman kailan yung entry because it is surreptitious. These are underground tunnels. That case does not apply here because what was built here are transmission lines. Hindi naman nakatago yung transmission lines. Okay? Alright. Alright, there is a complaint for unlawful detainer. The MTC ruled in favor of the plaintiff. Okay? The plaintiff files a motion for issuance of writ of execution. Defendant appeals. So from the MTC, defendant appeals. Okay? Now, in the RTC, okay, the RTC sustains the MTC, and the defendant further appeals to the CA by petition for review under Rule 42, and he is asking to further suspend the proceedings by filing supersedeas bond and periodic deposit of rentals. Okay? And the court allowed it. Is the court correct? No. Okay? Remember, under the expedited rules in first level courts, okay? From the MTC, the decision in unlawful detainer forcible entry is immediately executory, but you can suspend execution by perfection of appeal, giving a supersedeas bond with the approval of the court, and also by making timely deposits. But from the RTC ruling, the rule on expedited rules in first level court summary procedure provides that it is no longer further appealable. It is immediately executory, final, and unappealable. So from the RTC, hindi na pwede yung Rule 42. Ha? Isulat niya yan sa Rule 70 nyo. So you don't make a mistake. So the ruling of the RTC in its appellate jurisdiction in summary procedure for forcible entry or unlawful detainer cannot anymore be subject of an appeal. It is immediately executory. Remedy is certiorari provided there is grave abuse of discretion. But here, there is no showing of grave abuse of discretion, kaya certiorari will not apply. Okay? All right. During the pre-trial, the regional trial court declared the case submitted for judgment on the pleadings. Why? Because the defendant's answer failed to tender an issue. When does the answer fail to tender an issue? If there is a failure to specifically deny the material allegations in the complaint, or if you admit the material allegations in the complaint. Okay? All right. So, after there is a ruling of the court declaring the case submitted for judgment on the pleadings, the defendant filed a motion for reconsideration, claiming that his answer tenders an affirmative defense. The RTC denied the motion for being prohibited. Dissatisfied, defendant files a petition for certiorari alleging grave abuse of discretion. Is the petition for certiorari proper? No. The case here is not about judgment on the pleadings under Rule 34. It is about the motu proprio prerogative of the court after pre-trial to render judgment on the pleadings found under Rule 18. Under Rule 18, the court may, on its own motion, without prejudice to a party's motion, agree to rule to submit it to judgment on the pleadings if there is no more issue. And that ruling of the court, MR against that ruling is not prohibited. Ha? If you look at the rules on prohibited motions, the prohibited MR is an MR against the ruling on the affirmative defense. Walang ruling on affirmative defense dito. Sinasabi ng court actually na walang affirmative defense. So that is not the applicable rule. Ha? Don't think that there's no grave abuse kasi MR on affirmative defense is not allowed. That's not the case here. Ha? Because the court said walang affirmative defense, kaya pwede na mag-judgment on the pleadings. Okay? And if you look at the list of prohibited MR, the only prohibited MR is an MR on the ruling on the affirmative defense. But here, what is the subject of the MR or motion for reconsideration is the ruling of the court to submit the case to judgment on the pleadings motu proprio. Not prohibited ang MR, but if you look at the rules under Section 10, Paragraph 2, Rule 18, what is prohibited here is a certiorari against the ruling of the court to motu proprio submit the case to judgment on the pleadings. Alright? Okay. There is a criminal case for violation of the Comprehensive Dangerous Drugs Act. Okay? Now, the prosecution moved that it be allowed to take the deposition of a material witness who is a Filipino national, but the witness happens to be detained in Singapore for drug trafficking. And they're asking to take his deposition upon oral examination. The RTC judge denied that motion, okay, kasi it's outside the Philippine jurisdiction. Is this proper? Remember, as a rule, Rule 23 on deposition of witnesses would not apply in criminal cases because in criminal cases under Rule 119, there is a specific provision provided. And there is a different rule if it is for the witness of the prosecution and if it is for the witness of the defense. If it is a witness of the prosecution, as in this case, the only instance you can have that conditional examination would be if he is too sick or infirm, or if he has about to leave the country without any definite date of returning. Alright? Those are the only instances. And in that instance, you cannot just have oral examination, okay, by deposition. It must be in the same manner as a trial in court, okay? So since there is a specific rule applicable for criminal cases, Rule 23 will not apply. Yung mga more than 100 kilometers sa Rule 23, hindi yan applicable. Only the two grounds I mentioned for criminal cases, prosecution witness will apply. However, in the case of People versus Serio, Mary Jane was already confined in Indonesia on death row. And the government of the Philippines asked that there be a reprieve, that she will not be executed yet and she be allowed to testify. Indonesian government allowed this, but subject to conditions, she will not leave confinement, and it is only about before one authorized to administer oaths. She cannot go to court. So in this instance, the Supreme Court applied Rule 23 suppletorily because the situation here is not contemplated by Rule 119. Again, what is the situation for Rule 119? Witness is too sick or infirm. Hindi naman may sakit si Mary Jane. And she's about to depart with no date of returning. Hindi naman siya about to depart. Naka-depart na siya and on death row. Di lang siya makalabas. And the condition is that her testimony cannot be made in the Philippine courts pero doon sa confinement. So, the Supreme Court has relaxed procedural rules and applied suppletorily the rules in civil procedure in this case since the situation is not covered by criminal procedure. And that is it. Okay? So, these are the answers to the questions. Again, if you did not get the answers, do not feel discouraged. The point of this exercise is so that you know, okay? Walang gumagaling ng hindi nagkakamali. All right? Okay. So again, thank you so much for attending this lecture. I really appreciate it. And I again wish you all the best in the coming bar exams. I hope all of you do well in the bar exams. Thank you.